Hello everyone, this is Lexology with Solomon, again Solomon ጋር. Welcome back to my channel, and I am Solomon Shmedu. For those who are new for this channel, I am really excited to have you join my channel. I have some backgrounds in legal studies and also in some aspects of business studies. So on this channel I cover some topics that brings legal concepts into our everyday lives, and mainly focusing on the Ethiopian legal system. So today's video is kind of different for the fact that it's my first video in English, and even if actually it is in English, I'm still focusing on the Ethiopian legal system. And the reason why I am making this shift, it is actually not a shift. The reason why I'm making this video is the first thing is it's an academic content, and in Ethiopia, as our medium of instruction is in English, then it is kind of very important to make those academic contents in English and make it more inclusive for those who are interested only in those academic subjects. And the second one is it's kind of also an experiment for me, because I am hoping to know and understand my audience's preference, especially for those educational topics, whether it is better in Amharic within our local language or in English. So I'm hoping that this video would help me to identify the preference of my audiences specifically to those academic contents. And the last reason would be it's kind of personal. As you all know, guys, most of us, we study for probably more than a decade in English, but it is still a bit of leap to speak on public platforms like this in English. So I am using it also as a personalized breaker opportunity. So if you enjoy the idea, I would really like to have any feedback, any of your comments and ideas. So please let me know. I would like to hear what you are thinking. So having said this, let's get started and let's dive into our today's topic. Today we're going to look into the first and introduction part of Ethiopian contract law. Mainly I'm going to focus on the general aspects and what is actually is a contract. The first part would be this one, and in the second part I would look into the sources of obligation from the legal perspective and also from the general societal perspective, and the third one would be why contracts or contractual agreements are important in our everyday life, and the last one would be we're going to look into also what is the definition provided for contract under the Ethiopian legal system. We are fortunate enough to have a clear and concise definition of contract under the Ethiopian Civil Code, so we are going to have a brief look into that definition. So the next part would be what are the sources of obligations, guys. Now let's take this step further, like where do our obligation came from, or where does your obligation came from? In other words, what makes you responsible or accountable to do something or not to do something, or to perform something that you have promised, or things like that? What makes you responsible and accountable? I mean, for me, many of my obligation begins or comes from the value that I inherit from my society, my culture, and also from my religion. All of these things influences the way how I think, the way how I act, and the way how I try to keep the promises that I gave to someone. Then of course there is a law. So in legal system, obligations are usually divided into the civil obligation and the criminal obligation. So whenever we discuss about contract, just bear in mind we are talking about the civil obligations. The criminal aspect of the obligation is another issue, but next time maybe I will try to look into what is the difference or what are the aspects of the civil obligation and the criminal obligation. But for now, just the takeaway point is contractual obligations are part of civil obligations, and contract law or contract itself is also a source of civil obligations. Have you ever made a contract before? That is another question. What do you think, guys? I mean, I bet I can tell like your first instinct answer would be yeah, of course. Yes, I have made a contract before. But let me ask you this again. What kind of contractual agreement comes to your mind first? Is it kind of something big like buying a house, selling a car, or signing an employment contract? Or do you think of something that is more casual or routine, like taking a taxi and grabbing some lunch food from food vendor, and even buying some vegetables from street markets? Which activity or which kind of engagement comes to your mind when you read the question first? That is the point. Because believe it or not, each of these actions that I mentioned can actually be considered as a contract. You don't always need to sign a document to form a contractual agreement. So every activity in our everyday life, it involves contract, whether we think of them as a contract or not. So every time when we make an agreement to exchange something of value, which have some of economic importance, we are forming a contractual agreement, even if we do not think of them as a contract. For example, like pay for a cab ride, like paying for a Lucy taxi or ride or something. So those are contractual agreements. And in legal terms, a contract does not always mean a paperwork, guys. Just make sure that one. Of course, there are special kind of contracts that requires written agreement and even sometimes notarization or registration with the government or municipal authorities, like buying a car or purchasing a home, when there is a substantial interest involved in that transaction. But in general, or as a principle, a contract is just an agreement between two peoples where there is an exchange of promises or commitments that has some kind of economic value. For example, we could say when you pay for fast food at the street vendor, there is a simple contract in place because you promise to pay and they promise to give you a food. So if one of you doesn't follow through, then the contract is broken. That is going to have some kind of legal consequence. And the same concept applies where you are buying an items, goods or services. It doesn't matter. So why is the contract law important? So I think now we understand that contracts are actually the fundamental parts of our everyday life. But why are they, or why the law governing the contracts is really important? What do you think is the reason? Well, I'm going to give you some kind of scenario where you buy something important, maybe rare item that you cannot find it easily, and you buy that thing from someone who has owned it for maybe a decade. But the next day the seller changes his mind or her mind and wants the thing back because they got more better offer from someone else. What can you do? There is nothing you can do without a legal contract or a contract law that protects you. So there would be nothing stopping them from taking that thing back because still they are presumed as the owner or the possessor or anyone who has right over that property. So that would make our life and the society very chaotic. Like the lifestyle of the society would be like the fittest would survive. You just take someone's property and then next time yeah, no, I'm gonna pay, I'm not gonna pay. And then you take someone's money, and then no, I'm not gonna deliver the goods that I promised, and things like that, because you are the fittest. So the main important contracts and contract law is that contracts are backed by law, which gives us some kind of stability and also predictability. Like they protect our rights, our property, and ensures that when we enter into an agreement or any kind of contractual relationship, we know they are going to be upheld before the concerned authorities. And that is why contractual agreements and also contract law is really important. They make it possible to engage in transactions, knowing that if something goes in a wrong direction, we have some kind of legal recourses. So we can say actually contract and contract law is our foundation, especially in the modern society. It is a foundation of trust in any of the modern and democratic society. So now we're entering to the last one. So what is contract under the Ethiopian legal system? As I told you, or as I tried to mention before, we are fortunate enough to have a definition provided under the Ethiopian Civil Code about what contract is, because most of the times in our legal system we do not define, especially the Civil Code, it doesn't define terms or words, legal jargons in a clear and concise manner. But we're lucky enough to have a clear definition about contract. So Article 1675 of the Ethiopian Civil Code, it defines contract as an agreement whereby two or more persons, as between themselves, create, vary, or extinguish obligations of a proprietary nature. This is the definition provided for contract. Of course, it sounds very formal and maybe difficult to understand, but from here we can count like at least 5 elements. As you can see, those points that are colored, the first part is a contract is an agreement. It should be between two or more persons, and it should only be between those who are negotiating the contract, we say between themselves, and it may be also to create, vary, or extinguish. And the last one is the relation should kind of involve proprietary nature with something of value. Value means economic value. It really needs to involve some kind of economic aspect. So now we're going to look into these elements one by one. So let's go. The first element of the definition is an agreement. What do you mean by an agreement, guys? So think of an agreement as a mutual understanding between kind of two or sometimes more and more people. It is just mutual understanding. It is when two or more people share a common intention, a common idea, and express it to one another, either through words, actions, or sometimes even through implied gestures or kind of conducts. So when both parties demonstrate this mutual understanding, we say there is an agreement. But guys, here is the interesting part. Just because there is an agreement, it does not mean there is a contract. For an agreement to be a contract, the parties must intend to be legally bound by it. They really need to have that sense of bindingness in their mind. So it is not just a piece of paper that makes a contract. I mean, the paper is just a proof. What matters is their shared intention and their clear obligation and the assumption of the fact that they are binding by that shared intention or understanding. So here is a simple example. if you sell your laptop to your friend for like 5,000 birr, then there is a contract because it involves obligations, and also there is, I mean, clear intention. He's gonna pay, you are gonna give the laptop. But if you just loan your laptop for some days, or it's like for, I don't know, weeks, then that's just an agreement. There is no sense of bindingness involved. So you would probably, if you say, okay, I'm gonna borrow you my computer for a week, then if you need it on the third day, you can just ask him like, oh, I need my computer, so you need to get it back for me. Then he cannot refuse it, and he's not gonna just bring you to the court of law and then saying that yeah, we agreed to use we agreed to allow me use his computer for a couple of weeks, but now he's asking me to give him back. No, he cannot do that, because there is no intention to be bound by that, because the other guy is doing that as a friend, but it is not in a sense of bindingness. So contract, it is not just only about mutual understanding or mutual assent, it's also that sense of bindingness that plays a most important part. So alright, moving on to the next key part, it says 2 or more persons. So this is an important distinction of a contract from unilateral legal acts. So it is not something that one person can create by himself or with himself. It needs at least principally 2 persons or 2 parties. So for example, one person cannot enter into a contractual agreement with himself. You cannot legally make a promise to bind yourself or to promise to yourself to do something, because you cannot take yourself to the court because for the reason that you yourself do not follow through that promise. That's absurd and that's impossible. However, there are some exceptional cases where a person might seem to be acting on both sides of the contract, especially when it comes to agency issues. So imagine an agent representing 2 parties, one of as a buyer and the other is as a seller, guys. So in such cases, it's kind of possible to have a contract where an individual acts in 2 different roles, but this comes with really tight and strict rules, because it kind of tend to affect and create a conflict of interest of different parties involved in that contractual agreement. So under the Article 2188 of the Ethiopian Civil Code, for example, an agent can make a contract with himself on behalf of a third party, and this scenario can create some kind of self-dealing or dual agency. But because this situation, as I tried to mention, could create a kind of a conflict of interest, the law gives the principal, the one who appoints the agent, the power to either approve or cancel that kind of contract that the agent concluded with someone in the sense of dual agency. So this kind of safeguards and also helps us to avoid divided loyalty, and also ensures kind of fairness in the system. So the other point would be contract, it should be between themselves. What do we mean by between themselves? This might be a simple phrase, but it's actually a pretty significant element of the definition. So what do we mean by a contract that should be between themselves? Means that it only binds the parties who are directly involved in that contractual agreement, either in a sense of negotiation or in a sense of inheriting or accepting that negotiated obligation. So in other words, contracts are private agreements, and generally they should not affect persons or people who are not part of that agreement in the negotiation process or in any kind of involvement. So this is known as the principle of privity of contract, and according to Article 1952 sub 1 of the Ethiopian Civil Code, contracts are generally they produce effect on people to create them between the parties who made the agreement, but there are again some kind of exceptions that I am going to mention for you guys. And the exceptions are, for example, 1957, the Civil Code, it allows parties to conclude or agree a stipulation for the benefit of the third party. What do you mean by that? Let us say that your friend make an agreement where you agree to pay your friend's sisters or brothers, the siblings, school fee, and in this case the siblings, your friends, brothers and sisters, are the third party who benefited from the contract entered into between you and their brother, even if they were not part of the initial agreement. But in general, the default rule would be no one is going to assume any kind of obligation because of a contractual agreement negotiated by two persons. If he is not involved in that negotiation process or in that contract creation process, he is not going to assume any kind of obligation. But when it comes to benefit, of course, who hates benefit? For benefit, if it is benefit, then third parties, they can also be benefited from that contractual agreement, even if they were not part of that initial agreement. The other point would be the purpose of the contract. Why people enter into a contractual agreement? I think you can see the image here. Someone is signing on a paper. Take a look at this image, and then what do you think they are doing? I mean, are they creating a new contractual agreement, or are they just ending or terminating their agreement, or maybe even are they changing some of the contents of the contract? What do you think, guys? Even in this image, what do you think they are doing? Well, I mean, if you are not sure, don't worry, like that would be the correct answer, and I hope you are not alone. But looking at this one, especially this image, some smart gesture reader might say those persons are creating a contract. Why? Because they seem happy and they are laughing, but that is not necessarily true, guys, because they could be amending the contract. They could be like changing some parts of the contract in terms of the prevailing market value or market instances, and even they are also probably ending it. After all, like, there are always ways to end contract or any kind of relationship on good terms too. So we cannot really tell if they are just starting a contract, changing a contract, or just wrapping up or ending the contract that they had. So here's the interesting part. All of these things, either you are creating a contract or just amending a contract or even ending a contract, they all count as a contract. So every kind of activity, just to create or to end or to amend, they are contract. So all those actions, parties who involved in all those actions are actually required to fulfill the requirements provided for the creation of a contract. And so finally, guys, let's talk about one last but very important element of the definition, it says contracts deals with obligation of a proprietary nature. Now we need to ask, what do we mean by proprietary nature? What does it mean, like proprietary? So it means that a contract must relate to something of economic value or material value, something that has a financial aspect, guys. This could be either a good, property, money, or service. It can be anything, but it needs to have some kind of material value. It's not just about sentiment or some kind of personal attachment to that property or a thing, but it needs to have value that can we quantify in a certain way. So a contract that involves kind of personal or social relationships, like promises to stay friend and a promise to do something just without a sense of having that binding nature, they are not going to be considered as a contract because they are not generally enforceable, because they do not have that proprietary obligation. The good example would be adoption, betrothal. In some places, they in some parts of the region, they have been treated in the family law. In some aspects, they do have some contractual element, but their status, like betrothal or እጮኝነት, adoption, ጉዲፈቻ. So those things are status. They are not a contract because there is no money involved, there is no financial value involved, or there is no such material thing involved. Even marriage is not a contract because the main purpose of marriage is not proprietary. Of course, it does have some proprietary effect because when two people join together, they probably have their own property when that they get when they were not together. Then they can have some kind of contractual agreement on how they are going to manage those private properties. But those could be kind of considered as just to manage the property aspect. But when we say marriage, it is not about property. Typically, it is about two soulmates just finding each other and then getting married to live together, to cooperate and to consummate and to spend their life together. It is not about money at all. It is not about property at all. So marriage is like, as you understand, guys, I think there is no need to explanation. It is more about personal status and less about economic exchange. But as I mentioned, there are some kind of contractual issues or civil issues that would arise from this contractual or this marriage issue or from adoption issue and things like that. So, but mainly any kind of contract to be considered as a contract, after fulfilling the rest 4 elements that we have discussed before, it also needs to fulfill this last element. It needs to be proprietary nature. It needs to involve something that has value, which can be quantified in a certain way, which have some kind of financial aspect or money aspect in a certain way. So that's the thing. I think we are done here for today. Just to sum it up, as I tried to mention, guys, contracts are everywhere in our everyday life and in our major life decisions. So contract is for the backbone of our societal trust and also legal accountability. So the thing is, they are not just a word on paper. They are commitments, they are protections, they are importantly like the promises that we rely on. Like we used to say, "Yalut kamitafa yoledut yitfa." That is what contract is all about. So the main thing is contracts. They do not have to be complicated, but understanding them, it it can save you from headaches like when you enter into a contractual agreement. So understanding how a contract works, especially in the context of Ethiopian law, it would give you some insights on how the society functions, and also helps us to navigate our responsibilities in a society or from the legal perspective. So the next time you buy something even simple as bread, injera, or some vegetable from a street market, just remember, guys, you are engaging in a contractual agreement. Just bear in mind. So for today, this is what I have. I hope you enjoyed the content, and also it helped you in a certain way. If you find this video useful, please like, subscribe, and let me know in the comment section if you have any question about contractors or other legal topics that you would like me to cover. So I really would like to hear your opinions about this specific academic topic. Until next time, guys, keep exploring. See you again.